appeal is a matter of Howard and Joseph for the Home Department.
Yes, Sir James, I'm sorry we kept you waiting.
My lords, my lady, I appear on behalf of the Secretary of State, Mr. Underhill. Mr. Kaufman and Miss Brown appear on behalf of the respondents. This is my appeal from a judgment of Mr. Justice Swift of the 23rd of April 2021. I'm assuming that the court has had the opportunity to have a brief glance at the skeletons.
We have had the opportunity and we've taken it.
I'm great.
More than a brief glance, too.
Yeah. So I think the first thing to deal with is time. I certainly do not anticipate that this appeal is going to take all day.
No.
It was listed for, I think, originally for 2 days when there was an Article 14 set of arguments that were in play, but those have gone. So we're basically down to the bare bones of rationality, on which I suspect there isn't going to be, as reflected in the welcome size of the appeal bundle, in terms of authorities, there's not a great deal of dispute about principle. I was planning to go straight in.
No, that's fine. I think our assumption was the same as yours, that we'd be very surprised if this lasted any like a full day, but let's see how we go.
I'm grateful. I wanted to start, if I may, with 3 points on basic principle. The first of them is that the context involves the setting of policy by the Home Secretary to deal with mandatory, non-waivable good character requirement that Parliament has set as a precondition to citizenship. The legislative scheme you have and the key provisions are set out in our skeleton, and I don't think you're going to cause any controversy. See paragraphs 17 and 18 and 19 of the skeleton. If you want those provisions in the raw, they're behind tabs 5 and 6 of the authorities bundle.
I'll just look at them for the order's sake. But, yes.
So you've got a provision that allows or confers power on the Secretary of State if she thinks fit to grant a certificate of naturalisation, in effect citizenship, if, but only if, certain legislative preconditions are satisfied, fulfills the requirements of Schedule 1, as you see in Section 6, Sub 1 of the BNA.
Yep.
And then paragraph 1 of Schedule 1 to the BNA sets out the preconditions, including under 1 sub B that the person is of good character.
Yes, a term which we all think we know what it means, but is not in fact defined anywhere.
Exactly so. It also contains a series of other preconditions of the kind that you see referred to in paragraph 1 of Schedule 2.
Can I just pause there, though I say we all think we know what it means. I'm not going to be rash enough to attempt a definition. But it's essentially concerned with conduct. Someone is of bad character if their conduct is, it would be tempted into a definition, which I don't mean to be, but in some way antisocial. Typically that will be criminal conduct, but it doesn't have to be. Is that...
that's about the shape.
That's about the shape of it.
That's about the shape.
The reason I make that point is at a later stage in your submissions, I will want to just be exploring the relationship between non-residence and good character.
Yeah.
Non-residence.
Well, I'm going to come back to that point very specifically for obvious reasons.
Yep.
But my lord is right. So, and you'll see that the policy is mostly directed to trying to set some ground rules about how long criminal convictions hover over people after they've been made. But it plainly extends as a concept beyond criminality. And so, for example, one has had in the past lots of arguments about open and closed hearings in circumstances where there are concerns of an intelligence nature that ground a worry about good character. So it plainly extends beyond criminality. But conduct is, one imagines, is the core of it. Very difficult to think of an example of thought crime for this purpose. but conduct would probably base it. In any event, the core point on the statutory scheme, having described its basic nature, is that there is a mandatory requirement as a precondition to the grant of citizenship, which is good character, and unlike some of the other preconditions, it is non-waivable. So there is provision in para 2 of Schedule 1 for waiving some of them, fees and taking sufficient knowledge about life in the UK and so on, but good character is not one of them. So Parliament evidently regards good character as important. However, the scheme plainly does leave a wide discretion to the Secretary of State to design policy which in nature will set the parameters of the good character requirement. That policy is established effectively under common law powers. We're not dealing with a set of statutory provisions that say the Secretary of State must produce policy or must produce guidance which has this effect. It's simply produced as a matter of the ordinary exercise of common law powers that ministers have. And of course, if that has any significance, it is effectively that the discretion is as broad as that sort of common law power ordinarily is, bounded in effect by rationality. It is perhaps, however, important to bear in mind that there might at least be Padfield arguments.
Yes, I was about to say, rationality must Padfield must always be relevant.
Padfield, we respectfully submit, would of course in principle be applicable and relevant, but one can see the force of potential concerns about Padfield if you set up the policy in a way that effectively steps outside the bounds of the statutory purpose, under which, for example, citizenship would be granted on some other basis than good character. So there is at least a concern of that kind, which I'm going to come back to, lurking in the background, and that is obviously particularly or potentially problematic in circumstances in which you are considering relaxing otherwise applicable policy, itself considered appropriate as a way, an effective way and a lawful way of giving effect to that statutory purpose. You're considering relaxing that for a particular group, and indeed doing so on the basis of considerations that actually have nothing to do with good character, but everything to do with seeking to deal with another non-character related issue, such as righting historic wrongs. But that simply introduces another level of policy consideration, if you will, and another potential level of legal complexity into the judgment call that the Secretary of State has to make, or is at least is entitled to make, under this statutory scheme. So that's the basic legal setup and structure of the legislative provisions which the court is considering. That's the first point. The second point is that this case is concerned with an irrationality finding. That is
sorry,
a court.
I can't resist probably anticipating what you're about to say, but a slight difficulty I've had in analysing the judge's reasoning is that he unquestionably frames it in irrationality terms, but the irrationality really seems to consist in departure from the Windrush statement, effectively departure from a statement of policy, not the policy we were just looking at, but a different policy, which is a different basis of unlawfulness.
Could be.
Yeah, but potentially a different basis of unlawfulness. But this is an irrational policy in itself. It's an irrational policy because it departs from the Windrush statement.
Yes, or if you, and I'm going to return to the intersect, I think that lies behind my Lord's question, between the idea of, for example, legitimate expectation on the one hand and irrationality on the other. But my Lord is right. This is irrationality in a failure to alter the policy.
Yeah.
The policy itself is perfectly obviously rational, as it applies across the general piece. But the reason for emphasising that this is an irrationality finding is a slightly different one,
Yeah.
for this purpose, which my lord, my lady may need no assistance on, but the test it is as well to bear in mind is a very high test. And that's why we've reminded you, if reminding was needed, of the famous Lord Diplock statement in CCSU, so outrageous in its defiance of logic or of accepted moral standards that no sensible person who applied his mind to the question to be decided could have arrived at it. I mean, that is as stated and as recently adopted in the War Boys case, DSD and the Parole Board, my learned friend, I think, was in. That is the nature of the test, and it's a high test. And it's a high test because it recognises that in some circumstances, and these conform to that, Parliament has left the design of policy and policy judgments, here in relation to the good character requirement, in the hands of the Secretary of State. It's also to be borne in mind that it's an objective test. Could a sensible person have come to the view that it was right to leave the good character policy where it stood, rather than making an exception is the nature of the test. And it isn't, I emphasise, to reinforce the obvious, and obviously this drifts between policy and application, or principle and application of principle, but this is not a test that says be a bit wary before the court decides that a reasonable course might have been something different. And there is, we respectfully submit, a need, particularly in a context perhaps where the siren call of merits is relatively powerful and of sympathy is relatively powerful. This is a principle which cannot simply be stated, it has to be applied, so that when you actually reach the ultimate question, you are asking the right question. You're not just saying the court needs to be a bit careful before it intervenes. You are actually recognising the force of the principle. And the leeway to which that strong language that Lord Diplock set out in CCSU, it is to be borne in mind, exists for very good constitutional reason. Because it acknowledges the primacy of decision-making that Parliament has conferred on the executive and not the courts in this sort of area. So that's the second point. Again, all very obvious perhaps, but perhaps needing to be restated. Thirdly, the context here also indicates that the range of rational decision-making before the court intervenes to interfere with that primacy of decision-making by the Secretary of State is and should be a broad one anyway. Any policy on the design of the operation of the good character requirement could, of course, be more or less forgiving, if that's the right way of looking at it. That is quintessentially a matter of judgment. It is perfectly possible, without defiance of, or outrageous defiance of logic, for a sensible person to draw lines in myriad different ways about which reasonable people can perfectly properly differ. There isn't a right answer in a sphere like this, and that's particularly so because we're dealing with a policy which engages, in effect, considerations of social policy, in which the benefits of citizenship flow from the grant. And we've noted there's something of a small issue about one point in relation to that social context. We've noted that if granted citizenship, amongst other things, has the potential seriously to curtail the ability of the state to respond to future criminality. And that is because once citizenship is granted, Section 40 of the BNA, which I know at least one member of the court is very familiar with from the Shamima Begum case, Section 40 allows for citizenship to be deprived in limited and strong circumstances. My learned friend Ms. Kaufman says in relation to that, yes, but you're wrong to focus too much on that because, and she's right in this, Section 7(1) of the Immigration Act 1971 prevents deportation of Commonwealth and Irish citizens who have been ordinarily resident for 5 years at the time of conviction. She's right about that. And that would no doubt apply to prevent deportation of at least a significant percentage of the Windrush cohort. But not all, is our first answer to that, or riposte to that, riposte to us. Not all. And in any event.
Why not all?
Because there will be some people in the Windrush generation who have not been resident for 5 years.
Or because they have travelled back? Or
yes. So not all. But in any event, as the courts have recognised, that there is still social policy engaged in the removal of citizenship, even detached from the effects of that removal on the possibility of deporting people in the future. And that's why we've put on the bench, and I put it there only to refer to it very, very briefly, we put on the bench the Aziz case and a judgment of Lord Justice Sales, as he then was. Our learned friend, I think, handed up Section 7, I just referred to, so you have that. The Aziz case at paragraph 27, I think, is a relevant one. Yes, I think it's paragraph 27. And again, it wasn't directly an issue here. This isn't a great big point of principle. But paragraph 27 acknowledges that the removal of citizenship is not just about removal. So that teed up a particular issue in that case, which you don't need to be concerned about. The point I make is the broader one, which is that there are still social issues around removal of British citizenship, even if, for a significant proportion of Windrush, Section 7 would operate to prevent their deportation in the event that they commit crime in the future. So we make the more general point, to bring it back to this third submission about basic principle, that this is a social context for all of these reasons, and it isn't, that characteristic of it, of the context, is not removed by reliance on Section 7. It remains a social context for obvious reasons, and it particularly remains a social context even for those who might have an indefinite leave to remain that couldn't be taken away by deportation if they commit crime in the future, because there are broader issues to do with the package of benefits, oft commented on, most recently by the Supreme Court in Project for Registration of British Citizens, the benefits, the package of benefits that flow from citizenship. So those are the three basic points of principle that I wanted to draw attention to at the beginning. Can I then turn to the application of those principles in the present context? The essential question we submit is whether it fell outside those wide bounds for a rational Secretary of State to decide to leave the good character policy unchanged so far as those falling within the Windrush generation is concerned. And by and large, we had the debate around what the Windrush generation meant in the context of the Article 14 argument below. We don't need to trouble you with that. I'm taking that essentially as meaning those who came and settled in the UK from Commonwealth countries prior to 1/1/73, 1st of January 1973. That's the question. And it's not in truth a decision about this individual's case, or I'll come back to that, or the decision making in this case. You have the various decisions in all their permutations in the core bundle between pages 187 and 201 if you want them. But it's not about that. This is essentially about the policy question. And the starting point, we submit, is that Windrush, as an issue, has been recognised repeatedly by all concerned, repeated Home Secretaries, and indeed Parliament, as giving rise to special considerations because of the acknowledged injustice that they suffered. The question, that's the premise for the question, the question was and has always been what to do about that historic injustice. And the answer in policy terms that has been given by the government is to put in place a whole variety of measures to assist the Windrush generation in relation to their immigration and citizenship position. So as part of that, the Windrush scheme was set up, and again, I don't need to go into the detail, but if you have our skeleton argument to hand, we have summarised in paragraph 31, by reference to the evidence of Christian Armstrong below, over on page 10, call bundle on the red numbering CB022, we've summarised between A and I the various measures beneficial to the Windrush generation that have been taken in effect to deal with the historic injustices they have suffered. Now, all of those steps, as you will see, share some common characteristics. They are all designed to ameliorate their position as a group. They are all reflected, or all of them reflected, in effect, respect for what the Secretary of State could do as the executive within the boundaries of the legislative scheme, in brackets, waiving certain requirements that the Secretary of State was allowed to waive, as I indicated when I went through the statutory scheme, but not good character. That's not waivable.
When you say legislative changes, these were all secondary legislation?
They were.
Yeah.
They were. Many of the Windrush generation, including Mr. Howard, you will note, had ILR in any event. So were entitled to remain. And indeed, if they'd done the 5-year thing, Section 7.1 provided them with protection against deportation, even if they committed future criminality. There was no undertaking or promise or equivalent that as part of this package of measures, they would or could simply be given British citizenship in reflection.
Well, I think Ms. Kaufman would refer, anyway the judge refers, to the statement in the Windrush statement, which effectively says, and I'd better remind myself of exactly what it says, as quoted by the judge, anyone from the Windrush generation who now wants to become a British national will be able to do so. That goes rather wider than you were just suggesting, wasn't it?
Well, my lord, that's got to be read in the context, amongst other things, of the statutory scheme.
Well, that's fine, but I think it's not right to say that there was nothing to suggest that effectively all you had to do was ask and you would get it. That is exactly what the then Home Secretary.
Well, my lord,
Yes,
can I come to that statement in due
yes, of course. I don't want to take you out of order, but
no.
Yeah, right.
But there is a problem with that. There's a problem because of the statutory scheme.
Yeah.
And there's a problem of the intersect kind that we were discussing earlier.
Yes.
There was originally a claim in these proceedings that that sort of statement, and there are others, British status in all but name or whatever was said, however it's put, that those had in effect created a promise, a legitimate expectation, and that claim was abandoned. And it was abandoned for jolly good reason.
Well, fine. Come back to it when you get to it.
The core point here, however, is that this, within the limits of power, represents simply a set of judgments about what can and should be done to remedy the historic injustice. And you'll bear in mind also, as part of this, that the answer to that policy question, what is to be done about that historic injustice, also involved the setting up of a generous compensation scheme, accessed by Mr. Howard, who I think was paid something in the region of 130 odd or a bit more £1,000. So that's the basic policy answer. What then about the good character policy as it stood and as it stands? That good character policy, which you've seen described in the skeletons, certainly our skeleton at paragraph 21 and 22, it may just be worth going to this in the wall perhaps. It's in supplemental bundle, I think number 2, if you can lay your hands on that. And the one that was applicable at the time, and I put it that way because, as you're aware from the judgment, the thing changed. Yes, you'll see the history and derivation of all of this in paragraph 27 of the judge's judgment, just for reference. The page I want in supplemental bundle 2 is page 258, which should have the heading on it, Annex D to Chapter 18, the good character requirement.
Yes, there's 2 lots of paging.
The red ones are the one you want, S2199. The ones in the middle of the page, if you haven't had colour printing. That should be a document heading, yes. Annex D, Chapter 18.
Yes.
That's the one that is referred to in the judge's judgment at paragraph 27.
Oh, sorry,
supplemental bundle
no,
2?
I've got the Annex D, though it's actually, it's described, but behind tab 5, it's described as page 199.
Yes. Sorry, did I give you a duff reference? S2199.
No, perhaps you didn't.
You gave us the 258 number.
Oh, I'm so sorry. I was getting confused. Yeah, 199, so sorry. And the page I wanted to, I'm going to do it again, 203.
Yeah.
And just to apply this to Mr. Howard's case, to give you the flavour, as it were, but no more, because it's a more general policy question anyway. But you'll see the table at 2.1, bottom of page 203. And you'll see the reference to the word normally in each of the boxes, right-hand column. And you'll note in particular number 4. I think his sentence was common assault, 12 months suspended. So he falls within number 4. There might be an issue about whether he should fall within number 4 or should fall within number 3, but that is resolved by Roman 10 on page 205. Which treats suspended sentences as falling within non-custodial for present purposes. So effectively the policy is, or the table indicates, that if you commit an offence falling within that table of whatever description, that's going to be strongly indicative of you not getting citizenship for the relevant periods. But that is not an absolute position, as is reflected by the word normally. And you'll also bear in mind, so far as that is concerned, that the policy itself sets out the possibility of exceptions. Putting flesh on the bone of or introducing some new idea matters not. Flesh on the bones of normally or introducing some new idea matters not, because if you go forward to page 225.
Sorry, yes, just normally is glossed at Little Roman 15. Perhaps you took us to that now, so we can do something else. That's right. Space.
Yes, normally is glossed at Roman 15, you're right.
And then
and if you're right next door to that, see page 225.
Yeah.
because that's the exception should be made only in exceptional circumstances.
Yeah.
And then you'll see that at page 225, under section 10, there is exceptional grants. And there are procedural and substantive guidance. Got to go to the chief caseworker.
Let me just. Yes, so those are reasons why exceptionally the conviction in question should not be regarded as meaning someone is not a good character.
Generally. And subject to normally, which is why I said, well, it slightly depends how normally ties with exceptional circumstances. But that, either way, that's how it works.
Yes.
And of course, bear in mind that this is in nature policy anyway. And by legal nature, policy is capable of being departed from.
Well, of course, but
for good reason.
As you emphasised earlier, it is all by way of a policy about the approach to an absolute statutory requirement.
Yes.
So I think it must follow that even though the word generally is used in section 10, the circumstances that justify an exceptional grant will be circumstances which go to justify the conclusion that someone is of good character.
Yes.
Not that they, this is a point I suppose you really want, not that they've been treated badly in the past.
In some other way.
In some other way.
And that is by and large reflected in sub B on page 225.
Yes, right. Hang on 1 second. Yes.
So that's the policy as existing and as applicable to his case by way of example, as it were. You will also bear in mind in relation to the application that, as you saw from...
Sorry, can I just flag up, that may not be the point to deal with it. I wouldn't mind understanding, although it's not an issue, the basis on which...
There was a moment at which that became worrying.
Sorry?
There was a moment at which that became worrying.
The basis on which the eventual grant was made in this case, because I just want to understand how that fits into the...
I'm going to come to that.
Yeah, okay, that's fine.
I respectfully submit it's a relatively subsidiary issue because the judge was
In
effectively
a
relying
sense,
on...
it's a non-issue,
Right.
because there's no challenge, surprisingly, to that. But I just want to understand how it's consistent with the legal analysis which you're advancing. But
Can I come to that when I do?
yes, of course.
I promise I will.
No, fine.
Note also that, as you saw or will have seen from, I think it was Ms. Rouse's statement, two Secretary of States at least, and again I'll return to this because the judge relies upon inconsistency of decision making, one of his features, but two Secretary of States have in fact considered this policy and have in fact considered whether changes should be made to accommodate the Windrush generation in some shape or form by, in effect, introducing good character light, if I'm allowed to use that phraseology just by way of summary. And just by way of explanation, because it's a slightly odd setup of all of this, but the issues were developing as the trial was going on, effectively. And originally there was an allegation, or a clarified allegation, made relatively late in the day. I don't need to get into the procedural shenanigans, and I intend no criticism of a learned friend. But there was an allegation introduced about whether or not Windrush had even been considered. So there was a kind of Thameside point that was being done. And it was for that reason that the Rouse statement was put in saying actually it was considered. And here are some extracts from the ministerial submissions that went up and so on. So that was put to bed, and it then, as it were, morphed into something more like a substantive irrationality challenge. But in any event, the point for the purpose of the substantive irrationality challenge is that two Secretaries of State have considered the issue whether the policy should be changed to accommodate Windrush. So my starting submission is that it's very difficult to see how a decision to leave the good character policy in place, that is a policy itself unimpeachable as an approach more generally, the decision to leave that in place for Windrush, who benefited in all the other ways described, could be said to be so outrageously in defiance of logic that no sensible person could have come to the decision. Which leads us into the question, well, what did the judge do and what factors played in the judge's mind? And there are perhaps 5 points to make in relation to the judge's analysis to pick up what I hope fairly reflects the core of his reasoning and give you my responsive submissions to those. First of all, and principally, as my Lord has already noted, the judge appears to have based his conclusion of irrationality on the idea that there was a mismatch or a lack of logical connection, as he put it, between not doing anything with the good character requirement to the speech in Parliament made by Amber Rudd when she was Home Secretary. And our answer in relation to that, or our submissions in relation to that, I was just going to give you for your note at that point the reference to the source of the Amber Rudd statement, which I think is in, someone get me that, I think it's tab 5 of Supplemental Bundle 1, but can I check that? Yes, it's Supplemental Bundle 1, page 124. Have it open by all means, as it were, but that's what we're addressing. 23rd of April 2018, middle page number 124. And the first submission we make in relation to this reasoning is that in principle, and just as a general point, the fact that a system is in one respect relaxed or altered to favour a group that has suffered injustice in some way does not logically lead to the position that you must do everything and anything that is open to you as a matter of power in all spheres. And it plainly doesn't lead there, because there will be, and there were in this case, questions of policy and political judgment as to how far to go and what steps precisely to take. It isn't simply bounded by your legal ability to do something. That would be to deny the existence of any policy judgment at all in this sphere. So that can't be right as a general proposition. More directly, it's perhaps critical to note 2 things about that statement. First of all, we respectfully submit there wasn't a promise, or in legal terms, because this would be the precondition and the framing of such a promise if it were made, a legitimate expectation created, that any particular aspect of the then current scheme, and I use that in its broadest sense to include everything to do with granting citizenship, would be changed. As I indicated earlier, the claim had been made at an earlier point of these proceedings that it had indeed created some form of legitimate expectation that the good character requirement would not stand in the way of British citizenship applications, but that was rightly abandoned below, not least, no doubt, because it was not competent to the Secretary of State.
I hadn't picked up that a legitimate expectation case based on the statement had initially been run, or therefore that it had been abandoned. What are the references for seeing that?
Well, the reference that I had was, I'm afraid, a reference to my earlier submission notes in the High Court. So can we check?
Mr. Blundell will find them.
Mr. Blundell will find them, or Miss Catherine will tell me if I'm wrong. But in any event, certainly reflected as a recollection in some speaking notes for the High Court. But the point is the Secretary of State couldn't make that commitment, couldn't make that promise, because Parliament has introduced a mandatory non-waivable requirement for good character.
Well, that's going a bit too far.
Well,
Parliament
sorry.
could. What the Secretary of State could, in principle, have said is what constitutes good character is a matter of judgment.
Yeah.
No particular magic in the table we've seen in Annex D. And I propose to set the bar
Yes.
for what normally counts as good character, somewhat, depends how you do the metaphor, let's say somewhat higher, somewhat lower. That, it seems, there might be room for argument about it, but in principle, that would have been something she could have said. At any rate, it's not obvious that she couldn't have said it.
Yeah.
What she couldn't have said, I quite accept, is I propose to dispense with the good character requirement altogether, except by promising to introduce primary legislation.
But that does introduce a qualification to the nature of the statement, which represents the high point of the promise.
Quite.
What it doesn't do, and I should have made the qualification explicitly clear earlier, but I hope it's been clear from my submissions, what was still open to the Secretary of State was to exercise the policy power to do what she could properly do, or he could properly do. That Amber Rudd was succeeded by Sajid Javid in the relevant period, as a matter of law. And there may therefore be constraints, even to, or arguable constraints, even to what could be done as a matter of policy, e.g.
Yes.
based in Padfield.
Quite. In 1 second.
Well, that's sort of hinted at in the passage from Ms. Rouse's statement, which the judge quotes in the judgment, because it seems that the officials at the stage when Ms. Rudd was considering modifying the requirement was saying, we assume you'd like to keep it because we don't want murderers getting citizenship. That would be presentationally difficult to defend, and it might be open to challenge because it could be said that good character is an objective requirement.
Yeah, my lady, you're right. I mean, I suspect that I'll come directly in due course as one of these points I'm dealing with to that part of the judge's reasoning. You're right. The concern in the mensub appears to have been either an objective requirement or a discrimination type concern,
Yes.
because the suggestion appeared to be that you would have to, if you were going to do it, you'd have to extend it to everyone, not just Windrush, who'd come here after 1173, I think it was.
Yes,
There was a
I read
suggestion-
it as the latter.
Yeah, there was a suggestion that was designed to deal with discrimination, but the point that I'm on, unmentioned, if I may say so, in the ministerial submission, but nevertheless existing, which may highlight why it's important to recognise that rationality is an objective test,
Yes.
is the kind of Padfield concern,
Yes.
the kind that we've been talking about.
In fact, though, we can't, it's very abbreviated, Ms. Rouse's evidence.
It is.
And it may well be that the suggestion you did it for everyone might actually help on the Padfield type point, because what the argument would be, look, you already recognise that things you did a long time ago don't impinge on your good character.
Yeah.
If you altered it in such a way that they had to have happened even more recently in order to count, that would simply be recognising that if you behave yourself for a number amount of time, that means it's reasonable to regard you as a good character. And as long as you did it for everybody, you would get the benefit for the Windrush generation.
But you would advantageously get the benefit of lots of other people.
But yes, but fine. But you'd have to take the rough with the smooth. I mean, you'd have to do it consistently because you were taking a view, prompted perhaps by the circumstances of the Windrush generation. But you were taking a view about the importance of how much time had to pass, and you were taking a general view about that.
Yes.
It would have been a bit subtle, but I think it could have been done.
It would be a bit subtle and a bit difficult and a bit complicated because, as with all discrimination arguments, if you shift the goalposts to try and include the immediately concerning comparator group, what that tends to do and can do and would do here is at least to set up another comparator group, at which point someone would turn up and say, well, I'm a person who is not Windrush and has not been here since 1173 or whatever the thing you do is to create a general proposition to get over the Windrush problem. But here I am, I'm in a directly comparable position to the other person who is not Windrush, who's now benefiting from this scheme, and I don't. What's the objective justification for that? You may have an argument, and it may succeed in court ultimately, that says, well, the answer to that is because we were trying to benefit the Windrush generation, and the only way of doing it was to avoid a discrimination argument, so we did it generally. But it feels complicated. If I'm allowed to use the technical legal terms, it feels quite hairy.
Yes.
in terms of legal risk to start going down this road. I mean, we're debating the legalities, no doubt because we're lawyers, but the truth of it is that this aspect feeds into policy.
Could it also be said that this discussion exposes the difficulty in identifying the quote-unquote logic of the statement? Because how do you give effect to the logic of the statement if you have to give effect to the good character requirement, and the ways in which you might give effect to the logic of the statement are rather various?
Yes, my lady, I respectfully agree. And I think, if I may respectfully say so, though, I mean, again, it may be too subtle for those listening to the parliamentary debate, but the fact of the matter is it's bound, that statement is circumscribed in any event by the mandatory requirements of law, but it's also, it also raised the issue my lady has just put to me, but the resolution may be that when the statement was made, it wasn't just those headline-grabbing statements that were set out in it. Specific steps were identified in that statement as things which the government was going to do.
Yeah.
Now, the fact of the matter is that you haven't got, therefore, or you've got a statement which in nature contains those big, bold statements, but it also then goes into the specificity of the steps that the government is proposing to take along the lines summarised in my paragraph 31 of the skeleton. And none of those, is perhaps the punchline at that point, include anything about any either waiver of the good character requirement, because that couldn't be done as a matter of law, or any indication that the current policy approach to good character would be altered. But it did set out positively a range of other steps that the government was proposing to take. The underlying point that the judge appears to be basing on is to say, well, this doesn't really work logically. I'm trying to be fair to the judge. This doesn't really work logically because you, the government, the Secretary of State, have changed lots of other matters, brackets all of those referred to specifically in the Windrush statement. You've changed lots of other matters. Indeed, you changed lots of other matters to the limit, as it were, of your power to deal with the historic injustice, but not this one. But the answer to that, I respectfully submit, is firstly that that is false reasoning, because one change doesn't logically imply no discretion or no legal room to do, but to do everything within the limit of your power. And secondly, it depends on it not being possible rationally, as an objective test, to distinguish the things that were done from the thing that we're considering now, which wasn't, which is to change the good character policy. And in relation to that question, can you rationally distinguish between the two, just in general terms? My short submission is that of course you can. Parliament itself, albeit at the higher level, as it were, Parliament has treated them differently. Good character as a requirement is non-waivable, although it leaves a broad discretion to design policy to the Secretary of State. Parliament itself saw a distinction between the good character requirement on the one hand and the other things that were preconditions that were indeed waivable, that were the subject then of the Windrush statement as steps to be taken. So there are, at the very least, entirely recognising the distinction between legal impediment and policy permission in the statutory scheme, there are, at least it can be said confidently from the statutory scheme, there is a different set of issues associated with good character. Secondly,
just on this point about logic, one point which occurred to me that the judge had in mind, that I think there is a difficulty about, was to say that the underlying logic, of which the phrase that I drew your attention to earlier is the clearest expression, anyone from the Windrush generation who now wants to become a British citizen will be able to do so, is that effectively they should be put in the position that they would have been in if they had exercised the rights that they had up to 1988 or whatever the date was when they finally became too late, which wouldn't have included a good character requirement. That was the logic of the statement. And this simply doesn't go far enough. But I imagine your answer to that would be...
See murderer and primary legislation.
Yes. And that's not the way it's not the way the judge himself actually says. He says they should have done something. He doesn't say what, but they should have done something to mitigate or ameliorate. Mitigate's probably a better word.
If the logic is a requirement, if the logic is perceived as a requirement of result.
Exactly. The logic proves too much. Yeah.
Well,
sorry, that's just me thinking aloud.
Yes,
but I suspect you would agree.
But my lord, I respectfully agree, and it's helpful that you do. I mean, if the logic is the logic of result, it is undeliverable. It's a different way of expressing the same thought. But in any event, even at the lower level, and when you're considering policy and policy change and whether those can be distinguished from the sorts of easy things, we won't charge you a fee, all the other waivable conditions, they're all easy.
And the judge himself in paragraph 35 recognises that there's a constraint, i.e. the statutory constraint. So in a sense he's saying, I accept the Secretary of State could not have waived the good character requirement, but the statement required him, as it then was, to modify it in some way.
Modify it so as to achieve that result. And because...
To modify it, but to modify it in a way or according to principles which are unspecified. Perfectly legitimate for the judge to say, not for me to write the new policy, but if he says to be modified, he says to be modified somehow, according to certain parameters.
Yeah, and because that is a way of testing whether the decision to leave it alone falls outside the rational parameters. But we do respectfully submit that in point of principle, and in fact in this context, there plainly are distinctions between the sort of things that were done, which appears to be the premise for the logical attack in the judgment, the things that were done, waive the fee, jolly easy, and changing good character as a matter of policy, even leaving aside the discussion we've just had. I mean, as we discussed earlier, the legal issues and the legal risks and the complications are very different. And those legal risks are an aspect of and reflective of policy decision making, because policy decision making tends to be based, or at least in attempt tends to be based, on coherence as well. And as you've seen from the, again, I'm going to take this quickly because we discussed it already, but as you've seen from the min subs quoted in Ms. Rouse's statement, the concern appears to have been discrimination. Hence the suggestion that, to Amber Rudd, that it should and might need to be extended to everyone, not just Windrush. The judge made the point, at this stage, the judge made the point that said, well, you shouldn't have taken into account the fact that a differential approach might have left the amended policy vulnerable to legal challenge, but that can't be right. It must be permissible to identify the existence of legal risk.
Does he say that in the judgment, or was that an exchange in argument?
No, I think he said it in the judgment. It was something like that.
Rings a bell. That may not be quite.
May not be quite how he put it. I don't know if it or not.
Oh yes, you're quite right. It's over the page, paragraph
37.
Yeah. Doesn't come close to being a compelling reason. Quite right.
I've now lost it, my lady. Where
Yeah,
are
it's
you?
at the top of page 74 of the core bundle.
Yes, sorry, you're right. Yeah, first line on page 74. See, there is using the language of compelling reason.
Yeah, not come close to being a compelling reason.
But compelling reason is not the rationality test. And what we're really exploring here is an issue of lawfulness, legal risk, and its associated policy implications. I mean, one can't, just as a matter of proper approach, you can't say the identification of legal risk is irrelevant, or that it's irrational in some way to conclude that it existed. I mean, we discussed earlier, if the concern was discrimination, particularly bearing in mind Lord Reed's recent statements in SC and other cases about how easy it is to mount almost everything is discrimination nowadays, because other status doesn't really exist and you can always find a comparator group that reflects the prejudice that you say you've suffered. But as we discussed earlier, it isn't just a question of doing the thing that was suggested in the min sub, or it might not be, make it applicable to everyone, because then you just create different comparator groups which themselves would create legal risk. What that illustrates is not merely that there was a potential legal problem, but that the Secretary of State was actually grappling with a policy problem about how to draw the line, where to draw the line, who should adventitiously be included if the solution recommended in the min sub to Amber Rudd was adopted. Who should be adventitiously benefited? These aren't just legal issues, although they're reflected in legal risk. These are policy issues, and they emphasise that this requirement raised a whole host of difficult and different legal and policy problems that were simply non-applicable to the sort of steps that were being considered and were then taken in relation to the non-waivable requirements. But I also add all of the concerns which weren't mentioned in the min sub, but that doesn't matter because rationality is an objective concept, and what we're after here is whether or not there is a rational distinction between good character, change of policy, and other non-waivable requirements. I also add in the serious concern that, did I confess, struck me very forcefully when preparing for this case, of the risk of statutory purpose, where you effectively say, well, there you've got a mandatory non-waivable requirement that Parliament has imposed. The statutory purpose is that the Secretary of State should make judgments about how that requirement should work that are centrally and exclusively based on good character things. If you introduce the pollutant of extraneous considerations, you run the risk of introducing a legally irrelevant factor, but you also introduce cutting across the base and prime purpose of the mandatory non-waivable requirement for good character. So that's the first set of things that makes it obviously different and distinct, both in legal and policy terms. It might be thought also that there are other distinctions between good character, change of policy on the one hand, and non-waivable on the other. I mean, in policy terms, good character focuses, and again, this may be the thought that my lord was putting to me right at the beginning of this, good character focuses, I was going to put it on the basis that it focuses on the voluntary commission of criminal offences or other aspects relating to character. One can put that as it's based on conduct point, but there's a degree of voluntariness, it's your own action that brings this thing about, to put it at its crudest. It's far less obvious that making a change in policy so as to create good character light on the basis of other matters falls into the same camp at all. Next, good character raises its own and discrete issues about whether the package of benefits that British citizenship brings with it should, as a matter of social policy, be conferred on people. And it also brings that specific set of issues around the trammelling of the powers of the state to react to future criminality. Now, as I said earlier, I don't want to get too far down the debate on that road. Certainly some of them, they would be able to stay anyway. In relation to others, they wouldn't. And it is much more complex, I respectfully submit, to work out how to change it for this cohort. And the logic of the thing that compares this to a big broad statement that says everyone who wants to be a British citizen can be, that it's much more complex to work out how good character should be changed for a cohort whose circumstances are far from uniform. The judge says, well, it's irrational to maintain the policy, but he doesn't identify with any precision what the alternative should be. Now, as we discussed a minute ago, of course it is possible in theory to have a position where the court declares the current position is irrational and then says it's not for me to tell you what the right answer is. That's regularly done, and that's a proper reflection of the primacy of the judgment having been conferred on the decision maker whose decision is quashed. But the testing of alternatives is of real interest to whether the current policy, plainly rational in all other circumstances, is irrational in its maintenance. So that's what we say about the logical connection aspect. But the second point I wanted to focus on is a point that the judge didn't make so directly, although it appears to underpin quite a lot of the thinking, at least implicitly, but my learned friend makes more overtly in her skeleton. And it's related to the first point, which is that the Secretary of State, it is said, didn't have a proper regard to the fact that the good character requirement only applied because of the Secretary of State's own historic failings, which had left those in the respondent's position having to satisfy the good character requirement at all. Well, the first answer to that is the one, again, that we discussed a minute ago, which is that it proves too much. Because the logic of that is you'd have to get rid of the good character requirement, and that's simply not allowed, because the primary legislation makes it a non-waivable duty to consider that. But secondly, and with more punch in terms of at least practicality, the historic context was entirely clear and evident. That was the whole purpose of the changes that were introduced in the Windrush scheme. What it did not mean, what it did not lead to as a matter of logical policy, was that there then had to be changes to all aspects of the process for applying to citizenship, to the absolute limits of the Secretary of State's power to deliver that. That was never promised. And that was never, could not possibly be conceived to be part of a rational answer, or the only rational answer to this set of policy and legal issues. Perfectly rational, I respectfully submit, to introduce the sort of steps that were referred to in the statement specifically, take those forward, but then to consider and recognise the difficulty of the issues to which good character gave rise. That leads to the third point, which was that the judge placed significant reliance on the fact that two different Home Secretaries had taken two different approaches. And you know what I'm going to say about this aspect. But the first thing, before I say what is staggeringly obvious, the first thing I say is that I leave aside the fact that, if I'm allowed without disrespect to call it this, the Rudd approach was not in fact finalised in any new policy, which is why the thing had to go back before Sajid Javid when he became Home Secretary. There was a decision in principle, in effect, to take forward some of the recommendations which would need to be worked through in their detail. That's why the matter then went back to the next Home Secretary. But the answer of principle that we give to this reliance by the judge is that the difference of approach between two Home Secretaries does not indicate or support or establish, still less, that the later approach was an irrational one. It demonstrates no more than that two rational decision makers properly instructed about the relevant legal and policy issues could reach different views. Indeed, if anything, the fact that two different Secretaries of State reached two diametrically opposed views on what the right answer was, if that's the position, and query, given the detail that would need to have been worked up about how the policy was to have been changed and the precise legal issues to which it might give rise. But if anything, it demonstrates the sensitivity and difficulty of the issues. And for all the reasons I gave in my first point, rightly so, because the issues in relation to how the good character policy might have been changed are complex, or were and are complex and difficult.
So, as we use an analogy from the employment world, there's a range of reasonable responses to a policy question, and each of the two solutions was within that range.
Yes. You could decide you want to make some change. You want to take on some degree of legal risk. Sometimes ministers have high legal risk appetite, as you know. Sometimes they don't. And life is more or less comfortable immediately as a result. But that's the way it works.
Or two different judges coming to different conclusions on the same set of facts.
Exactly so. But here there's a constitutional angle to it.
Yes.
Because the point is there isn't a right answer and a wrong answer, even if one accepts that the policy should be changed.
No.
So it might be thought to say that a decision not to change the policy is irrational is
Very
perhaps
difficult.
going a bit far.
Yes. I respectfully agree. That was the point I was making about testing the irrationality or rationality of the position by reference to what the alternatives would be. And again, if you start thinking it through, the legal issues take you in one place, and then you immediately have a policy issue of some other kind, and the way you might go gives rise to a different set of legal issues. It's not an easy thing. But if it's not an easy thing, that is antithetical to rationality or irrationality. That's the third point. The fourth point is to deal with the long-term residence and integration point. Again, the judge says in relation to that no significance was attached to that. And the first point to make, perhaps three short points in relation to that, under that heading of long-term residence and integration. The first point is not entirely clear why mere residence and integration without more actually touch good character. Of course, one can quite see, and indeed the table that we went to earlier is premised on this idea, one can quite see that the longer the period without offending, or since conviction, the more it might be possible to say, I am now of good character. That's the essence of the idea of rehabilitation. But why residence and integration without more should touch good character, which is the essence of the characteristic of the Windrush generation that the judge appears to have been concerned about here, is much less clear. And indeed, that sort of thing does raise the kind of Hadfield concerns that I was making submissions about earlier. That's the first point. Second point, in any event, the policy itself leaves the door open to any matter that might be thought to bear on, or to be argued to bear on, good character. Normally, admitting of exceptions in paragraph 10 that we looked at earlier. And of course it is a policy. So in legal nature, you can depart from it for good reason, even if it's expressed.
So there could be, it's conceivable that long residence or factors linked to long residence integration could impinge upon good character in a way which was encompassed or could be taken into account under the normally or exceptional circumstances.
Yes, I suppose. I mean, I have to be a bit careful because of the first submission I made under this head, which is that one might need to be a bit cautious about just looking at long residence per se, but there may be discretionary elements at the end in relation to the grant of citizenship into which it might.
Well, my lord put it quite carefully.
Yes.
Long residence or
Integration.
or factors
Yes.
that are associated with long residence.
Yeah.
I imagine you'd have less difficulty. We might need to work out exactly what we meant by it, but more you'd have less difficulty with the second aspect of that, because well, to make a very crude example, which may be too crude really to make the point, if you have been here for 20 years and during those 20 years have been volunteering every weekend to help with a youth group,
Yes.
that in a sense is an element of integration and non-residence. And the length of time you've been doing it is highly relevant.
Yes.
But it is nevertheless because of what you've done, which shows the kind of person you are in your conduct. That particular example doesn't work because, well, it might work actually.
It might work.
Yeah.
It might work, but the sting is in so that one can create consistency between the first proposition and the second. It just may not. You may need to be jolly careful about where the boundaries lie, because you would have thought that whatever you did rely on would need to have some rational connection to the idea of good character. So it would have to be something that genuinely bore on good character. And merely saying I've been in the country for 20 years without more might be thought to be quite difficult to justify in terms of good character. But if you introduce scout groups and everything else, then that might well do. But anyway, the policy is sufficiently flexible to allow for legally relevant considerations to be taken into account.
Yes.
And thirdly, if the point is a broader one that the judge is making, that the policy needed to be weighted more generally in favour of Windrush, well, that gives rise to a different question and a series of other policy choices, because there may be varying residence and integration periods that are legally relevant, let's assume. That's not quite the point he appears to be on, but whether or not you take a nuanced account of that, or whether or not you tilt good character in favour of all of the Windrush generation, even though some may have been here and not resided here for a long time because they've been abroad or whatever. I mean, that just throws up a whole series of extra and different policy questions that would need to be grappled with. Do you apply, in effect, the good character light across everyone who falls within the cohort of the Windrush generation, or do you make distinctions within it? Because it's inherent in the idea of long-term residence as a thing that the judge says we left out of account, that you are dealing with that. And so the logic of that would suggest that you restrict it to only a part of the cohort, so that it doesn't apply to those who've been elsewhere and haven't been integrated in that way. And again, all that does is to throw up the idea that this is not an uncomplex legal or policy set of judgments. The fifth point is that the judge relied on the facts of this case. The first point to make in relation to that is that this challenge is to the failure said to be irrational to change the policy.
But by the way, that I had it look formally. That is not the case. It is a challenge to, if you look at the claim form, it's a challenge to the refusals, which at that point have not yet been superseded.
It became
and they were individual cases. Now, of course, they were individual cases based on a policy. So in order to challenge the individual decisions, you'd have to challenge the policy. Now, clearly, the case took on a different flavour when, after the issue of proceedings, he was granted a citizenship.
And he's now sadly deceased.
And, yeah, but that probably is irrelevant.
Yeah.
For this point. But I haven't quite seen anywhere, and it's probably in the Sturluson argument somewhere, the Sturluson arguments below, as it were, a reformulation as this is now a challenge to the policy. But actually what the judge did at the end was he didn't cross the policy, he crossed the decisions. So I don't think this really undermines your point, but I just want to understand formally what decisions were being challenged and what decision the judge took.
It undoubtedly started life, my lord is right, as a challenge to the decision in this individual case. But as I say, by the time we got to trial, the water had flowed quite a long way beyond the bridge.
Was there any point in proceeding with the case
If it
was
a challenge
to establish a point of principle?
Yeah.
And therefore to challenge the policy?
Yes, because one of the basis on which permission was refused on the judge doing the paper application for permission was invited to refuse permission on the basis that the claim was academic.
Yeah.
The Secretary of State having
I hadn't spotted
withdrawn the latest of the refusals, and I think it was Sir Win Williams. He said no, it's not academic. So the challenge proceeded on the basis that it wasn't academic, and the reasons put forward for it not being academic were it raised points that were relevant to other cases.
My lord, my lady, I think that I'm sure your recollection is right, and I was just looking back in the core bundle at page 56 at the order that the judge made, which is perhaps reflective of the correctness of both your position and indeed the position of my lord the Vice President, which is, as you'll see, the decisions were indeed quashed, and it was the decisions that were declared to be unlawful. But that was done on the basis that they were taken in reliance on the quote generally applicable. Do you see that in A and B?
Yes, so that's really the judge's pragmatic way of making it clear that this was really
So if one looks at Sir Win Williams' order is at page 148 of the core bundle.
Yes, thank you. I'm sorry, I should have had that in mind.
And he says points made in the claimant's response show the claim isn't academic. And then if you go forward to tab 15, you've got the claimant's response, and that makes 3 points. Whether the good character of granted the defendant's Windrush scheme is unlawful for reason that inconsistent with the defendant's public statements.
Yeah.
Violates Article.
Which is a general challenge.
Yeah.
Well, that's certainly the way in which it was envisaged, and indeed I suspect that if it didn't have that generally applicable policy bit in it, I'm not sure any of us would be here.
No, quite. Okay, but
so that's
still, I just wanted to bottom that out.
Yes, well,
but
I'm
you
very
go on to
grateful,
make the point you were about
my
to.
lady. Yeah, and I was going to make the point because my lord was expressing interest in how the decision making had worked. I don't know whether you want to go through those documents. It's relatively self-evident what they were based on.
Do we know how the ultimate decision was reached?
Yes, and all the various twisting and turning before they got there.
Well, I hadn't
there was an original
looked at the
decision
twisting
which was
and
withdrawn
turning,
and replaced,
I
and then
didn't
another.
even notice we had evidence on it, and which shows I haven't turned every page.
Yeah.
But I have looked at the actual reasoned decision, which is at 103.
103.
Sorry, 198 in the core bundle.
Yes. Yes. And that's the final hurrah.
That's the part, but that is the definitive statement of the reasons
That's the grant.
for the grant,
Right.
of course, yes.
And
Says the reviewer considers the immigration history's current circumstances, in particular noting his long residence in the UK, the time that's now elapsed since his criminal conviction in June 2018, and his current ill health. Satisfied discretion should now be exercised in his favour on an exceptional basis. That, on your analysis, is not really quite accurately expressed, is it? Surely what he would have had to say is that the exceptional circumstances of the case, query exactly what those are, mean that your conviction in June 2018 doesn't show that you're of bad character. And they've really got to say that, I think. And he doesn't quite say that.
He doesn't quite. I fully accept that. And there is a question as to whether or not you can take into account what appears to be the principal distinguishing factor between this decision and the earlier ones. I mean, no doubt extra months had passed since the conviction was handed down, but reading between the lines, it looks as though this was double pragmatic, because it was based in large part on the degree of illness that the individual was suffering at that time.
Yes, I mean, long residence in the UK, that has always been the case. Length of time, as you say, only a few more months. I haven't worked out the dates, but yeah, most. Current ill health, that is the big difference. And I don't criticise the Secretary of State in any way. It was clearly a compassionate thing to do in the circumstances. But within the statutory constraints, it's a little bit difficult to see how compassion for someone being very ill, probably the Secretary of State appreciated terminally ill, is relevant to good character. Might, I suppose, be. I don't think the court is likely to want to address this.
No.
But I do want.
My lord, if the question is it easy or difficult to square all aspects of all strands of this reasoning with what I submit is the correct approach to the statutory scheme, it isn't entirely easy, and I acknowledge that.
But is it right that what he was doing here was reconsidering the good character situation in the light of the circumstances that then existed? Is that what he was doing?
Yes. Yes, and as one sees from the slightly tortuous path in the pages that precede this.
Well, that I haven't seen. Perhaps we should see. Well, you were going to show us those.
Well, I was going to show you those simply for completeness, and I'm not sure it's a terribly happy tale from my side of the court's perspective. But so you see it, if you go back to 185.
I dare say my lord and my lady have read these, but I'm embarrassed to say.
No, you'll see at 185, 10th of May 2018, we're going to issue a biometric residence permit. This is about ILR.
Yes, no, you
got that.
Absolutely. Perhaps I have seen these, but if we keep going, I've certainly seen that.
And then 5th of November, frightfully sorry you don't meet it, page 187. Now
now this is about citizenship.
This is about citizenship, see the second paragraph.
Yeah.
And the essential reason that is given, or reasons that are given, are on page 188. Between the first bullet, you do not meet the good character requirement. You can probably read the next 3 paragraphs.
Yeah.
Just to give you a flavour.
Yes.
And that does look strict and harsh, but it does look pretty much focused on good character and pretty much applying the policy. Yeah. But then there was obvious some degree of nervousness. It appears, I think, that Diane Abbott then made some representations on his behalf, as one sees at page 190.
Yes.
And that led to the withdrawal or reviewing of the thing, as you see from the first paragraph, 3rd line on page 190. A maintenance of the refusal. The essential reasoning is contained in the 3 bullets on page 191.
Yeah.
And again, strict application of the policy and so on. Then there appears to have been a concern in May 2019, 193, and I suspect the concern was probably we might need to expand on the reasoning or something. But anyway, a replacement letter, but nevertheless maintaining the decision to refuse, is issued. You see 193, the underlined 3rd paragraph.
But it's still the same.
It's still the same outcome. Slightly different reasoning, but this time.
Well, deep down, it's the same reasoning, isn't it? It's still based on the.
Yes.
I missed something. It's still based on the offence in the last 3 years.
It is. The only reason for drawing this to your attention, well, the 2 reasons are: firstly, to complete the picture, so you can see what actually happened in fact, But secondly, because you'll remember that in the judgment, the judge was, when he looked at the facts of this case, perhaps as reflective of the general attack on the policy or whatever, when he looked at the facts of this case, he was critical of the fact that, at least at some point in history, reliance was placed upon the earlier convictions.
Yes, I see.
Do you remember?
Yeah.
And you see those referred to on page
Yes.
195 in the
Yes.
three bullets
No,
at the
I see
bottom.
that.
Yeah, and then 196 you will see
Yes.
second full paragraph. Reliance on a slightly broader set of facts.
Speaking for myself, I do myself an injustice. I had read these.
I'm great.
I thought you were referring to there being evidence somewhere to the effect that evidence somewhere to the effect that the about the if some evidence equivalent to Ms. Rouse's evidence about the internal decision-making processes. There aren't.
Well, I think Miss Rouse's last two paragraphs deal with this change, about whether or not there had been any change when the grant happened, and whether the grant was
Well,
completely
you or Ms. Blunder will remind me of that, but we don't see lots of internal memos saying, oh, perhaps we want to change our minds. We just basically see the end product.
You see the end product.
Yeah.
And,
Oh, well, that's, again, speaking for myself, my lord and my lady will say if they want to know more, but
I wonder what
sorry,
was
the
meant by...
Rouse reference, just to give you the Rouse reference, I mean, you see in the last letter in the sequence, but the Rouse statement in relevant part is at S1, supplemental 1, page 65.
give me a moment. Yeah, that just really says nothing that you don't see from the letter.
Exactly. But there it is for completeness.
Yes, I'm sorry, my lord.
I just noted that on 196 in the long paragraph, the senator says, however, despite all these matters, I have come to the conclusion your application for British citizenship should be refused on the account of your criminal record. And then, I do not consider there are sufficient mitigating circumstances, which means it would be appropriate to exercise discretion and grant you citizenship. What's the reference? How does mitigating circumstances feed into this good character analysis?
I think he was he not running an argument for the hero at an earlier stage that says
196, red 196, scroll bundle, the longest paragraph,
Yes.
How can mitigating
circumstances be
circumstances,
relevant? I suppose in theory you could say, well, I did commit the crime and I did get
well, I wondered about that.
I did get 12 months, but you need to know that I was under intolerable stress because of this, that and the other. I can't remember precisely what
I was ill.
I was ill or something.
Yes, I think
you can see the connection. So mitigate.
it depends. Mitigating circumstances, in the sense, this looks like the kind of offence that would lead you to conclude I was of bad character. But there are all these circumstances which mean that it isn't nearly as serious as it seems.
I mean, there's definitely a logical connection back to good character.
Yes, that could work, although normally you'd expect that to be taken into account in the sentence. But perhaps that doesn't matter so much for the.
But subject to that, you can see a logical connection. And
but mitigating circumstances generally, I suffered a recent bereavement, not suggesting it has anything to do with the seriousness of the offence, or, as you say, historically I've been very unfairly treated. It's hard to see what that has got to do with good character. I mean, at first I was rather surprised not to find the British Nationality Act some overriding exceptional circumstances discretion to grant nationality on compassionate grounds or exceptional grounds. There isn't, is there? And thinking about it more fully, one can see why it might be not a power you ought to give to the executive, however constrained.
And however much they might have circumscribed inter alia by Padfield, some policy room for manoeuvre underneath the concept.
Of course.
is it permissible for the Secretary of State to look again at mitigating circumstances within the offence? Obviously, there was mitigation here which led to it being a non-custodial sentence. Can the Secretary of State look again at the mitigating circumstances, which might, I don't want to speculate, it might be a factor in this particular case, looking at what happened, the nature of the offence, the circumstances, the fact that he was ill.
Well, I think my answer to that is I'm not sure I want to close the door on that, on
No.
the basis that that would be an irrelevant consideration. And I put it
So you're not saying it would be relevant?
I'm not saying it would
No.
be irrelevant in all circumstances. I put it earlier on in a slightly loose way of saying you'd have an uphill struggle if those mitigating circumstances had been put before the judge and the sentence was still, albeit suspended, nevertheless a sentence of imprisonment. And so one might have a job saying that takes you into the place where you can decide that I'm a good character.
I mean, the 3 year gap is really almost any offence, isn't it?
Yeah, it is.
Well, it may not. It's a non-custodial sentence,
including by the deeming in Roman 10 only.
Yeah,
deeming is the right way of doing it.
Yes, but speaking of myself, I have no difficulty in saying, even if it did lead to a custodial sentence, to a suspended custodial sentence, but perhaps it led only to a fine. Say, well, look, I know this is something that, according to your guidance, I did in the last 3 years and shows I'm a bad character. But look at the circumstances of the offence.
And in answer to my Lord's question, you'd have
which
to say, and by the way, I recognise also that the judge took that into account and sentenced me to what he sentenced me to.
Absolutely, I don't see why there wouldn't be any element of double counting there at all.
No, you've got a broader vista, is the answer of principle.
Yes.
And as part of that exercise, might the Secretary of State look at the length of residence and the degree of integration?
Well, we're back to that. I mean, I respectfully submit does raise different issues or distinct issues because it's harder, I respectfully submit, without the scout troop or the good works or the conduct that led to it, to rely simply on the length of time you have been here as an indication of good character. I mean, normally to say that you lived in a place for 20 years is neutral, for obvious reasons.
You could have been living in a place for 20 years,
So what?
committing minor criminal offences for all 20 years.
Right.
Or even something short of criminal offences, but doing undesirable things on your computer.
Right. So one may be able to stretch the causal nexus back to the statutory concept, but there may be a limit, is the short point. Anyway,
There obviously would be a limit.
right. I mean, anyway, we're some way away from the core of it, I respectfully submit, because what all of these debates indicate is that when you're in this territory, you are in territory where there are plain and obvious distinctions because of the complexities, because of the issues, because of the difficulties, both in policy and legal terms, between this, on the one hand, and the sort of steps which the judge was effectively comparing them with on the other. Namely, waive the fee or something.
So we should disregard completely the circumstances which led ultimately to citizenship being granted on this appeal.
Yes, my respectful submission is that nothing that happened in this individual case either tells you or supports the proposition.
It could have happened to someone who wasn't part of the Windrush generation at all.
Even leaving aside whether or not the analysis in the final letter was correct, if compassionate, or incorrect, if compassionate.
In one way, perhaps just following this up, I think, one way in which perhaps, but just to test it, the decision could have been justified, entirely consistent with your analysis, would have been for the claimant to advance the circumstances that led him to behave that way in the doctor's surgery, which obviously was taken a dim view of. What he did, in a sense, wasn't all that serious, but you can't behave that way to someone in a vulnerable public position. I'm sure that's why that led to a custodial sentence. Yes. And say, yes, but here's the background, which to some extent would be Windrush-related issue, or might be to some extent Windrush. But anyway, here are the background circumstances, and I behaved in a way which is now completely out of character for me, under extreme provocation, and I was ill. And that means you shouldn't regard me as being a bad character. And we needn't express a view. I wouldn't propose we in our judgment express any view, but that's simply a good thought experiment.
It is.
For the kind of way in which
The policy might work even if unaltered.
yeah.
But my broader submission, and the harsher submission, if you will, that I maintain it for obvious reasons, is that even if you couldn't, on the facts of a case like this, make the current policy work, so that the right answer under the policy and the only lawful under the policy was you cannot have British citizenship, nevertheless, my submission is that it was plainly not irrational of the Secretary of State to take the view that the policy didn't need to be changed for all the reasons I've gone through. And so my ultimate submission is that, of course, a judge as experienced and wise as Mr. Justice Swift will need no introduction to the idea of rationality, but one needs to be very careful about, as it were, reciting the usual principles. And I'm not sure he did quite recite the right usual principle. Really, Lord Diplock, and Lord Diplock's extremity of language illustrates the breadth of the concept. But what you can't then do is to, as it were, recite the rationality as a high threshold, we all know that, and then in your reasoning, effectively come at this afresh and start making your own views. And there were flaws with the, I respectfully submit, there were flaws in the reasoning process that led him to the conclusion of this. So those are my submissions.
Because he sort of moves in paragraph 35 from talking about the rationality approach to talking about the decision not being compelled.
Yeah.
So bottom of page 73.
Yeah.
And
We see
compelling
that
reason
reference
over the
twice
page.
in the penultimate line on 73 and in the
And
top.
then over the page.
Yeah.
Two lines
The
down.
bit that we were looking at earlier.
So it almost looks as though
He's looking for a
changed
strong
his
reason.
mind about the test he's applying.
Anyway, that's what we respectfully say about his judgment.
Unless my lord, my lady have any points, I've got two utterly trivial points which I meant actually to alert you to yesterday, because I suspect neither you nor Mr. Blundell will have the answers at your fingertips, but maybe you could get an answer in short adjournment. One is very trivial. Annex D to what? What is an annex to?
We can certainly
That
find
perhaps
out.
that won't take long to answer, but I just and the other, a point of no materiality to the actual issues, but simply so as to be able to set out the history accurately in our eventual judgments. The judge says at para 1 that by virtue of Section 2 of the Jamaica Independence Act 1962, Mr. Howard ceased to be a citizen of the United Kingdom and became instead a Commonwealth citizen. I looked at Section 2 of the Jamaica Independence Act 1962, and that didn't appear to be what it said. It appeared to be said he would continue as a citizen of the United Kingdom and
Right. I'm sure we can.
and colonies. Although logically I see he ought to become a Commonwealth citizen because Jamaica had become one, but become a Commonwealth country. But
The bad news
it
is
couldn't
that-
matter less. But it's a little work just for someone to show me where I went wrong, or that or where Miss Justice Swift went wrong. I just want to state it accurately.
Yeah. Well, I'm sure we can find the answer to both of those. And apologies that your initial prediction of them being at my fingertips turned out to be wholly inaccurate.
I'm always impressed with Sir James, but I would have been seriously impressed if you had had them at your fingertips. Mr. Scoutman, of course, does, I feel sure.
I'm disappointed. You're not allowed to be the Vice President of State.
I can't keep my disappointment.
Well, I'm sorry. If some of you can't conceal your disappointment, I apologise.
Very well. Thank you very much, Sir James. Yes, Mr. Tuffin.
My lord, my lady, I was going to start by just taking us back very briefly, because it's where Sir James landed, to the decision, the second, or was it the third, refusal of citizenship before the actual grant.
Yeah.
196 was that.
That was at 196, and there was the question as to what were the mitigating circumstances that were taken into account, which I think, or rather I'd submit, looking at the entire paragraph, that it seems abundantly clear that the mitigating circumstances were his long connection and close ties in the United Kingdom and the hardship he had suffered under the hostile environment, having been caught up in it. So if you look at 4 lines down into that paragraph, the second paragraph on 196, or rather starting from the second line, discretion would normally only be exercised in exceptional circumstances where there are strong factors which suggest the person is of good character in all other regards, so the decision to refuse would be disproportionate.
That's a restatement, really, of
That's
what
the
the
statement.
rule. Yeah,
The rule is-
That's
and then-
consistent with Sir James's submission.
And then you go on to look at what is then cited as being taken into account. I have taken into account and attached significant weight to the fact that you came to the UK in 1960 when you were 3 years old and have lived here for around 59 years. You have always lived in the UK lawfully and are entitled to remain here pursuant to indefinite leave to remain. I also note that you've previously attempted to obtain confirmation of your indefinite leave to remain and have faced difficulties because of the uncertainty as to the evidence of your immigration status. However, despite all these matters, I have come to the conclusion that your application for British citizenship should be refused on the ground of your criminal record. I do not consider that there are sufficient mitigating circumstances, which means it would be appropriate to exercise your discretion.
So was the Secretary of State there taking those factors into account in assessing good character?
Exactly, and precisely. In deciding whether or not to disapply the standard good character requirements in Mr. Howard's particular case. So
But why would they be relevant to good character?
Can we come on to that? And I will make submissions about that.
Okay.
The question is whether they would be relevant or whether it would be lawful for those to be taken into account under the good character policy. That's the critical.
So just so we understand it, is your case A, they were relevant, and B, they were lawfully taken into account?
They were, my case is they were relevant and lawfully taken into account. Exactly.
So
Now-
it shows long residence and hostile environment.
Are both factors which it is lawful for the Secretary of State to take into account under Schedule 1, which is the statutory power, obviously, that constrains his discretion. So we have to look to that. And that statutory power does not prevent the Secretary of State in taking into account those factors in deciding whether or not somebody meets the good character requirement. They are not irrelevant or impermissible considerations. And it's notable...
Just where does that leave your rationality challenge?
That opens the door to my rationality challenge, and I'll come on to my rationality challenge, because I must do, that if as a matter of statutory construction, it is not open to the Secretary of State to take into account the principles which Amber Rudd, in her April 2018 statement, expressly stated drives the Windrush scheme and its content. If, as a matter of statutory construction, it is not permissible to take those into account, then my case is at an end. If, on the other hand, it is permissible, then my case very simply, or rather the judge's case very simply put, is insofar as Amber Rudd identified a set of principles that were to animate the way in which the Windrush generation would be treated for the purposes of, among other things, applications for citizenship, then those principles were required to inform decision-making in respect of all the criteria in Schedule 1. The Secretary of State's case is no, it's totally up to me, irrespective of whether there were such principles that were articulated. It's up to the Secretary of State to then decide where those principles are applied. And that's the essential difference between us. And his arguments about the logic are arguments based upon the underlying premise that if you articulate a set of principles which are going to animate your approach to a particular class of people, then you must do so consistently across the board. That is what logic...
Sorry, not you must do so, then you must apply those principles.
Yes.
So,
you must
let me
apply
just, if you articulate a set of principles that will, just give me that formulation again.
that will drive your approach to a particular class of individuals in relation to a particular decision that you are charged with taking,
Yeah.
and where that decision entails consideration of a number of criteria.
I think you're elaborating. It
Well,
was
that's-
simpler
that's
when you said it
because-
first time.
yes,
If you
because-
articulate a set of principles that will drive your approach to a particular, I'm putting this to a particular class of decisions, then it
particular
is
class of
unlawful
individuals.
not to apply those principles. Is that right?
Consistently across all criteria which fall to be satisfied in respect of that decision.
Are you going to come on in your submissions and tell us what the principles are?
Yes, that's exactly what I was going to do.
And wait, just that, I mean, that sounds plausible, is probably right, but where do we find
Principle.
your formulations? No, well, your formulation support as a matter of law, is it, see,
Well, this is
it's quite,
rationality.
I mean, is it Mandalia? Is it, I forget what the case is that is endorsed in Mandalia, Decision of Law Justice Laws. We're in the sort of area about if you state a policy, you've then got to apply it consistently.
So this is about reasoning. It's not about policy. We're not. This is not a legitimate expectation challenge. This is about a decision maker identifying the key relevant considerations that they are going to take into account. One can put it that way. That they have chosen to drive their decision making. They have identified, and there are many cases which say the relevant considerations are entirely a matter for the decision maker. Here, we have had those considerations articulated and identified by the decision maker and expressly stated.
And can I just ask another question, which I'd like you to deal with at some stage, but not necessarily now, and that is, what principle of law prevents a later holder of the same office from departing from that statement of principle, assuming you establish there is a statement of principle?
For good reason, that could be possible, but the point in this case is there has
but
been
what principle of law dictates that, because you're saying this isn't a policy challenge, so you're not suggesting that the Amber Rudd statement amounted to a policy which bound the Secretary of State. So if it's not a policy and you're not running a legitimate expectation case, what legal principle requires Mr. Javid, when he becomes the holder of the office, to take the same line as the line that was being explored by officials on behalf of his predecessor?
Well, he'd have to come back and he would have to articulate a rational basis upon which he is going to depart from that consistent set of principles.
Well,
in relation to that particular...
Why can't you just say I've got different principles?
Where does that principle come from?
Well, because those different principles would then have to inform the entirety of the scheme. So if he's saying, if the decision of, or the statement of Amber Rudd is identifying that I am introducing a scheme, the government is going to introduce a scheme, and that scheme is going to be animated by these principles, then as a matter of rationality, that scheme falls to be animated by those principles, and the different constituent parts that go to making up that scheme fall to be animated by those and driven by those principles. If somebody is going to come along and say, well, actually, I don't like those principles, and I'm going to adopt a whole different set of principles, they can do that, subject, of course, always to public law principles, but they must do that again in a way that is consistent. So it would be a different approach to the scheme, but
if the different approach was internally consistent, the fact that it was inconsistent with the previous statement, suppose the previous statement said I'm going to do this across the board, and the second statement said actually I've thought about it. It doesn't even, it's in a sense it's a logical accident that it's a different minister. I've thought about it, I've looked at it differently, I'm now not going to do it across the board. I'm going to make a number of piecemeal changes. It's a change. Why can't they change it?
Well, it ceases then to be a statement which is about the entire
Yes.
approach
Yes.
to
Yes,
that
it is.
generation.
It is. That's the difference. I agree. But why can't they make that difference? Why can't they change so as not to
Because
have a principle that applies to the whole class?
One would have to then articulate a justifiable and reasonable,
you're-
reasonable and
But
rational basis to take that
what you're
decision.
doing is you're applying the law about published policies to this statement. But you said earlier that this wasn't a case, it was about policy. So that's what I'm trying to understand, what the legal basis of your argument is.
So the legal basis of the argument is that there is a statement as to the principles that will animate the decision making going forward in relation to this particular cohort. There has been no re-articulation or restatement of those principles.
But it would have been
And
open. Would it have been open to Amber Rudd to have said? Would it have been rational for her to have said, or irrational for her to have said? I'm going to do these things, but I make it clear I'm not going to change in any way the good character provisions. Would that have been a rational policy?
In circumstances where she was identifying that this is what is animating her decision making, then in my submission, no, it wouldn't have been a rational policy. She would have had to, consistently with her approach, look at the good character requirement and ameliorate its effects because of the underlying principles. And those are principles of longevity, and we'll come on to what the principles are.
Well,
But
I think
that
perhaps
would apply across the board.
this has been a helpful first exchange, but I think we better look at what the principles are, rather than deciding that you're adverting to are,
Yeah.
because we're having the discussion slightly in the abstract.
Yes, and slightly back to front. That's my fault, I'm afraid.
And mine.
So the
Not yours.
principles, I think the best way to look into the principles, because they're nicely summarised in a decision in the authorities bundle, which happily we won't have to take you to on many occasions, but this is a recent decision of Mr. Justice Fordham. It's actually a permission decision, so its status is not great, but it's a very useful summary of the various different cases that have arisen.
Has he given permission for it to be cited in accordance with the practice direction? She asked pedantically.
That is something I am afraid that I had overlooked.
Yeah, well,
Well, hang on. Well, let's try and be helpful. First of all, was this an authority that is in the bundle? Is that
It is in the bundle.
Let's try and be helpful.
It is in the bundle.
always try to be helpful?
It's
I was
tab
wondering whether we
4
could-
of the bundle. I'm sure
Oh,
that
this-
Mr. Justice Fordham would not object. But
No.
we have not answered this.
That's not the point.
No.
Nor the test.
I'm sure he'd be delighted, in fact, to have his
Yes, that's
permission decision cited in the Court of Appeal. But no. I
Well,
only
it's on
asked
no authoritative status. I think you could probably incorporate it into your own submissions.
Well, if I might do that then, if I might simply... It's simply, I only wanted to take your lordships and my lady to it just because it's a it's a good encapsulation. I'm not looking at any ratio here, but it's a good encapsulation of his analysis of
which you
the nature
adopt.
of the
You
Windrush.
adopt for your submission.
Well, I haven't asked my lord, my lady. I can't. But Sir James, on the understanding that this is simply Ms. Kaufman speaking through the voice of Mr. Justice Fordham, coincidentally, do you have any objection to that course being followed?
No,
We'll put it out of our mind that it is Mr. Justice Fordham.
none, thank you.
So if the court
You can.
can put aside the voice of Mr. Justice Fordham and just imagine...
Can I
this
just
is
say,
me.
this is not because we do not... The rule about non-citation of permission decisions is an important one, so we don't all get drowned in authorities.
Yes, it is absolutely not to look at the ratio of this case, just as a helpful way to navigate through the different cases that there have been and to identify
Yeah. Okay. Well, I think
principle
I
that
am
animates this policy.
prepared to make that little intellectual adjustment, allows authorities to be referred to.
I'm grateful, and I just wanted to start. This is a little slightly a sidestep, but I just wanted to start so that we could identify exactly how Mr. Howard himself fits into the Windrush scheme and the Windrush generation. The term Windrush generation was used by Mr. Justice Swift to encapsulate Mr. Howard's situation, but there are many who are encompassed in the scheme whose situation is actually slightly different to his. His is the sort of classic, as it were, Windrush generation individual, and that's identified at paragraph 3, this cohort. And there
Sorry,
are
paragraph 3 of...
Paragraph 3 of the judgment, tab 4, page 155 of the bundle. And if the court just reads those two little Roman numeral paragraphs, it tells you...
Sorry, it's not 155. If your bundle's made up the same as ours, it's 153.
Oh, sorry, 153.
Okay, we will have a look at that.
The two components.
The two components, just so that you can be absolutely clear how his case fits in. And we can then... we go through...
Sorry, I'm not, I don't read that fast. Yeah.
As we move, if you can just move through the judgment down towards paragraph 26, but as you do so, you will see at paragraphs 8 through to 11, Mr. Justice Fordham just looks at the different individuals who come within the scheme whose circumstances do not fit into that, do not meet the two components, as it were. And then at 26...
Just hang on one moment. Why is he referring so much to Mr. Howard? Mr. Howard wasn't a party, was he?
Mr. Howard brought the case, and then his daughter...
No, sorry. Are we...
No, I think he's
No, what he's
referring
attempting to do-
Sorry. Am I completely on the wrong... we're looking at Justice Fordham's decision, aren't we?
Yes.
It's not brought by Mr. Howard, it's brought by...
No.
So
Mr.
what
Brown.
he's attempting to
But
do...
he's referring to the Howard decision.
No, I understand he's referring to the Howard, but I wonder why is he referring to the Howard
Because
case?
what he does is he looks at all the different cases that have been brought, challenging aspects of the citizenship scheme.
Yes, I see.
Under or the citizenship provisions in their application, Schedule 1 provisions in their application to people who are subject to the Windrush scheme. And he attempts to analyse the differences between them all and
Yes, I see.
the
Okay.
commonality.
Right, I've got the context now.
So that's
right.
how
Where were we going?
And then we go down to paragraph 26, and he looks at Amber Rudd's statement and identifies all of those aspects of the statement that were pulled out in Mr. Justice Swift's judgment as informing the principles. And then, and says at the end of that paragraph, this language of the then Home Secretary describing the policy positions of the British government does bring into sharp focus the subsequent continuation on the statute book of Schedule 1 criteria, and then goes down to 30. It says this: there is an important distinction reflected in the cases between a criterion on a statute book and its fact-specific and concept-specific application. This was the point encapsulated by Mr. Justice Swift in Howard when he spoke of criteria capable of pursuing a legitimate purpose in a reasonable and proportionate way, with the primary legislation leaving open to the Home Secretary to identify the specifics, either in regulations or through a policy.
So, I'm sorry to interrupt. How much of this isn't it quick for us to read to ourselves?
Just down to about 10 lines down, and then you will see there is an articulation of the principles.
You'd like us to read the whole of paragraph 30?
If you would, yes.
Thank you.
Presumably, halfway through the line starting measured recalibration based on principled standards. That must be, mustn't it, rather than principal. Yeah. read that.
And then we see in paragraph, if we turn to the judgment itself, we see, I'm so sorry, my lords and my lady, if we turn next then to the statement of Christian Armstrong, which is in, I think,
Well, sorry, just before you go there, and you've still got the judgment open if you have, can I
Yes.
invite you back to paragraph 27? You see there's a line about 10 lines down beginning terms with the continuation in the primary legislation of Schedule 1 criteria. And then you see Mr. Pennington Benton accepts. Can I invite you to read the next
Yes.
5 lines? 6 lines, down to 1 criteria.
Yep. Down to 1 criteria, yes, okay.
so then,
Yeah.
if we
Sorry, just before we go any further, Ms.
Yeah.
Kaufman, I think I lost how we got in because of the fuss about its status. Where are we going at this
where
part
we're
of your
going with
submissions?
this is to identify what the principles were that were expressed in Amber Rudd's statement.
But I haven't yet seen anything in Mr. Justice Fordham's judgment, which we're treating as your submissions, that really addresses that.
Yes, and we're going to come on to it. It's a combination of that, going to look at Christian Armstrong, and then looking at Mr. Justice Swift's own articulation of the underlying principles.
Just so I'm clear.
paragraph 35.
I've not read this authority of Mr. Justice Fordham before. I apologise for that. Does he qualify or in any way undermine in his judgment what Mr. Pennington Benton was accepting as recited in paragraph 27?
I don't believe he does, no.
So everything that is said in this permission judgment is on the basis of that
So,
assumption or statement.
yes, I believe so.
Well,
But, can I just read?
It wasn't a promise as to the ongoing contact of the primary legislation. The Windrush statement did not extend to any statement relating to the maintenance applicability in the primary legislation of Schedule 1 criteria. That was a given, as it were, before Mr. Justice Fordham, which there's nothing in his judgment which qualifies that in any way.
Yes, it's not a promise as to the content of primary legislation, the ongoing content of primary legislation. So, absolutely, it was not a promise that there would be amendments to Schedule 1, specifically the good character requirement, for example. That's absolutely.
Nor was it a statement of the relating to the maintenance and applicability criteria.
In the primary legislation of the Schedule 1 criteria. So, absolutely. So, in no sense is he saying that there was any promise to make amendments to primary legislation. And that's not what Mr. Justice Swift in any way, or not an outcome or a requirement of the judgment of Mr. Justice Swift. Mr. Justice Swift was quite clear that primary legislation remains intact, and what is under attack in his judgment is the contents of a policy made in the exercise of a discretion conferred by primary legislation. So nothing in section 27 is in any way inconsistent with the judgment of Mr. Justice Swift, which is only concerned with a policy implemented to give effect to primary legislation. So if we go from there to SB1 and to the statement of Christian Armstrong. Christian Armstrong, if I can ask your lordships, that's in SB1 and the relevant paragraph. So Christian Armstrong, we can see at page 23, is the deputy, was then the deputy director within the Borders, Immigration and Citizenship System, Policy and International Directorate of the Home Office. And he deals with the Windrush scheme in his statement.
So which page?
And if we can turn to paragraph 22,
Page?
it's at page 29,
Of supplementary 1.
supplementary bundle 1. If I could ask you to read paragraphs 22 to 24.
Yeah.
So those are the principles. They're the principles identified by Mr. Justice Fordham. They're those identified by Mr. Justice.
Sorry, where were they identified by Mr. Justice Fordham?
At paragraph 26 of his judgment. And they are those that are identified by Mr. Justice Swift himself in his judgment. We go back to the core bundle and to page 73. And then at 74.
Sorry, you're going too fast.
I'm so sorry.
I've just looking back at paragraph 26 of Justice Fordham's. But all these people are doing is referring to what was said in the statement.
Yes.
It's a very roundabout way. We can look at the statement for ourselves. How is it helpful to look at what Mr. Armstrong said about it, or still less what Mr. Justice Fordham said about it, when they weren't even addressing this question?
Because they are all pulling out, and we can be absolutely clear, what the critical principles were. Everybody has identified them, which animate the changes.
Will you at some point give us the principles that dictation
Yes.
speed, or refer us to the passage in the your skeleton argument, which identifies them?
So the principles are those that are then summarised in my submission by Mr. Justice Swift at paragraph 35.
Okay, let's look at paragraph 35.
And this, you have to look.
Yeah, I'm nearly there.
The second part of the paragraph, once you've got there, that's page 73.
Hang on 1 second. Okay, I'm in paragraph 35.
So if you take yourself down to the line starting the Windrush generation, about 11 lines down,
Yeah.
it then says, even allowing for the significant margin that the winds be reasonable standard permits any decision maker, there is no sufficient reason to explain why, when it came to the good character requirement, no significance was attached at all to the long residence and integration of the group, all of whom had arrived in the United Kingdom prior to 73, at least 45 years earlier. So those parts of the statement articulated by Amber Rudd that have been repeated and I've taken you to, boil down to giving recognition.
So this is what you're saying the principles
The
are?
principle, yes.
1, recognition must be given, you go on,
To the long residence and integration of the Windrush generation, just for shortness. In the context...
hang on 1 second. Yeah.
in the context of the wrong that was done to them in their being caught up in the hostile environment. So those are the sets of principles, that's a set of principles that drives the selection of this cohort for differential and special treatment. And that is what falls to be given recognition.
So it's one principle. Recognition must be given to the long residence and integration of the Windrush generation in the context of the wrong that was done to them by being caught up in the hostile environment. Done to some of them. Because they weren't, the Windrush generation, those who in fact required nationality weren't caught up in the...
No, this only applies to those who...
Yes, so it's, but
It
the
only
Windrush
applies to
generation is a
those
wider term than those who didn't. So you're effectively talking about those who only had indefinite leave to remain and had no paperwork showing it.
So in Mr. Howard's case is, and it was Mr. Howard's challenge, is absolutely one where he had indefinite leave to remain and absolutely no paperwork to show.
So your point is those principles encapsulated in that sentence you've just given us, applied across the board, should have been applied across the board to all factors to be taken and all stages of deciding whether to grant citizenship.
Yes.
And it was irrational not to devise a policy which didn't do that.
Yes, it was irrational not to make changes to the policy in relation to good character.
And these principles, and I'm focusing in particular on the long residence integration, are applicable, are relevant to all the matters, all the factors, all the stages, all the hoops which have to be gone through,
Yes.
including good character.
Including
And how does long residence and integration impinge on good character?
So that's the next question. So that's the is this impossible? Is it inconsistent with the statutory scheme to be able to take into account these factors in and so giving effect to the principles underlying the scheme? And we can see, firstly, in the decision making, that certainly at the time, at no point was it considered that there was anything inconsistent, because we can see the last two decisions, one refusing citizenship, but one granting citizenship, took into account those features, precisely those features. And it's also important.
That's not an argument of legal principle.
Of course it's not an argument of legal principle, but it bears on this. It has not been part of the Secretary of State's case that these matters are inconsistent on Padfield grounds. You would be acting for an improper purpose, were you to take these factors into account. And again, that's not an argument of legal principle. So I'll now move on to the legal arguments.
Well, hang on a second. The Padfield argument is an argument of legal principle.
No, but
and whether or not it's part of the Secretary of State's case, don't we have to consider it?
well, that was no. I was saying the fact that the Secretary of State has not made the argument is not an argument of legal principle.
I see. Sorry.
There is then the separate argument of legal
saying.
principle. There is then that argument of legal principle, which I will now confront.
Out of curiosity, though, since we've seen that it's far from clear the Secretary of State understood this point, if it's a good point. At the time, are you saying that this wasn't taken below?
No, it wasn't taken in the skeleton argument before this court. It wasn't taken. In fact, Sir James indicated this was something he began to think about when he was preparing for the appeal. But in fact, it was. Your lordship.
I'm afraid I didn't pick that up.
No, it wasn't argued, and it was your lordship who first put the point. So
I don't think that's entirely true, because there was a reference to Padfield very early on. But you're right. It has concerned me ever since I started reading the papers. But I wouldn't like to think this was a point entirely generated by the court. I think Sir James, was taking it anyway. Whether he took it below, I can't say.
So we obviously have to deal with that head on. You have a statute which identifies good character as a necessary criterion to be satisfied. There is no definition given to good character at all under the statute. So this is indeed a broad discretionary power on the part of the Secretary of State. It's one which, quite obviously, he has to exercise for the proper purpose of ensuring that he only gives citizenship to those who he considers should acquire citizenship, should properly acquire citizenship in circumstances where there is evidence on a very broad spectrum that they have not, or they have at times in their life, engaged in bad things, whether that be criminal offending or whether it be matters short of criminal offending or otherwise. But that discretion is entirely unencumbered by the terms of the statute, unstructured by the terms of the statute, but certainly encumbered by his power to decide whether or not somebody should be granted the status of citizen.
Well,
But if I might just continue.
yes.
He could, for example, in his discretion, determine that minor offending is not going to transgress the good character requirement, should he consider that people shouldn't be deprived of citizenship because they've just engaged in minor offending.
Yeah.
That would be possible. And that would not transgress the broad discretion that he has under the statute. And in my submission, he could equally decide, for example, in relation to minor offending, that he does and has under his policy treated as disqualifying an individual for a certain period of time. But in the case of individuals who have been here for an incredibly long time, lived their entire lives here, have Britishness in all but legal status, have suffered the hardships of the Windrush generation, of the hostile environment, that it is appropriate in their cases to decide that even if they have committed an offence that would otherwise disqualify them, given their particular circumstances, it is not the sort of bad character that ought to disqualify them from citizenship.
You're asserting that, but it rather depends on what you mean by bad character, and you putting air quotes around it doesn't really help.
The question ultimately is, what sort of bad character should disqualify you from citizenship?
It's not what sort of bad character. No, with respect. There's obviously, you're quite right, what degree of bad character in the sense it's used in the criminal courts should disqualify you. That's certainly a matter of discretion. So, I mean, in the criminal courts, having a 3-month thing for shoplifting means that you are subject, unless it's spent, means that you are technically of bad character. Clearly, the Secretary of State can decide that degree of bad character doesn't make you of bad character for naturalisation purposes. I've myself got no problem with that. But that is about the degree of your bad conduct. The fact that someone has done you an injustice in the past, whether the state or perhaps simply you've been a victim of some horrendous crime, which makes it compassionately, you might say this person, the ordinary rules shouldn't apply to them. I don't see how that can be brought within any meaning of bad character or good character. Good character is something to do with your conduct and behaviour, not to do with what's happened to you.
It is, but whether that good conduct should disqualify you from acquiring citizenship is not something.
But that's not what the statute says. The statute simply says the Secretary of State must be satisfied you're of good character, not the Secretary of State should be satisfied that you are of good character, or if you're not, that anyway, for particular reasons, you should be allowed naturalisation. That's just rewriting the statute.
The Secretary of State is still being satisfied you are of good character, but it's what is necessary.
No, it's an absolute. Look at Section 6.
But he is. He is being satisfied that you are of good character. But what counts as good character can depend upon particular cohorts and particular individual characteristics
let us
and
take
circumstances.
a member of the Windrush generation, somebody else, they commit identical offences, the member of the Windrush generation could be described as being of better character or not such bad character by reason of the factors that they are brought within
Yes,
the Windrush generation.
yes. For the purposes of this scheme, they are not of.
No, for the statute.
Sorry,
scheme.
of the statute, they are not of. They are of good character, given these factors that drive that particular drive the establishment.
The
of the
Lord's
scheme.
example
Yes.
really tests it. Suppose, so as not to make this avoid murdered streams, but suppose someone has committed an offence for which they've been sent to prison for 12 months in the relevant period. I forget what it is. And the Secretary of State says that you're not of good character because you committed this assault or whatever it was. But you are of good character because, although you committed the assault, you had a terrible problem 2 or 3 years ago because your employer sacked you because you couldn't produce the relevant paperwork and you were given the runaround by my officials. What's that got to do with good character?
It is something that impacts upon whether or not you consider that the fact that the individual has committed this particular offence ought to deprive them of their citizenship.
Well, no, you're putting that completely the wrong way around with respect, Ms. Kaufman. It's not a question of depriving someone of their citizenship. It's a question of whether you make a grant of citizenship to somebody who, on the face of it, doesn't satisfy the good character requirement.
Yes, so whether you treat that, the commission of that offence as a basis upon which they should be disqualified from applying for citizenship. I mean, my lady, you don't like the way I put it, but actually that is ultimately what the question is. Is the person to be deprived of the opportunity to acquire citizenship, given the commission of that offence, in light of all the surrounding relevant circumstances, whatever they might be? And take another example. It's an example in this case, and it's one of the factors that led him ultimately to be granted citizenship. It doesn't go to the Windrush generation, but it goes to general exceptional circumstances, which, if the Padfield argument is right, could never be an exceptional circumstance, and that is that somebody is on the point of dying. And they want to secure citizenship. All the arguments against giving them citizenship on the basis that they have that criminal conviction, for example, that you would lose the opportunity to deport them, put aside whether this is somebody from the Windrush generation or not, all those arguments fall away because, of course, the person has a limited lifespan and is not going to be in that situation. But on the Padfield case as put by your lordship, that is not something that would be permissible.
No, it wouldn't.
Yeah.
It wouldn't. But the problem is not me. The problem is the statute.
But in my
I suggest what your argument should be repackaged as, but can't be, I'm afraid, because it would be in Article 14 if it was anything, but that would have difficulties too, is the Secretary of State should have said that I will seek primary legislation to allow me to modify the requirements of good character in the case of people in the Windrush generation. The problem is the absolute nature of Section 6 read with paragraph 1 of the schedule. I'll let you ponder, unless you have the perfect reply you want to give me right now. Shall we come back to this at 2 o'clock?
Yes, indeed. Let's do that.
Could I also just ask you to reflect on a question that's worrying me, which is that your argument seems to involve a submission that what you've identified as the principles should in some way inform the construction of primary legislation.
I do not for a moment contend that the arguments based on principles should do anything in relation to primary legislation.
Right. So
they should inform the content of the policy.
Okay. So you're not arguing that the principles should somehow.
I'm not trying to
the
persuade this
construction of
court to revisit whatever construction it gives to Section 6. If the court is not with me that Section 6 and the arguments I am making about how a policy can give effect to these features, if the court is not with me that there is nothing inconsistent with Section 6 and Schedule 1 in the policy being adapted in that way, then that is the end of my case.
Yes.
I'm not asking this court to revisit Section 6. That's a separate argument, and that would have to be run under the convention. And that's something that we, as you know, we've abandoned that argument for the purposes.
2 o'clock.